One.
Good afternoon. Welcome to the Connecticut Paid Leave Authority webinar on the new Paid Leave Act and what you need to know. I'm going to start by sharing my screen, finding the slide deck. Just a few housekeeping moments while we get started. We are recording so that this recording is available to you. It will be available within a couple of days if you would like to have access to the link. We can also share the slide deck. We would like you to put any questions you have in the Q&A function in Zoom. That way we can keep track of them and I can make sure that I'll respond to them. The slide deck takes about a half an hour and there's plenty of time for questions in the second half of the hour. So if you could hold your questions to the end, that would be great because I really can't see when questions are coming in when I'm sharing my screen. I'm going to get started and we'll just go from here. As I said, my name is Erin Choquette, and I'm the General Counsel for the Connecticut Paid Leave Authority. Before joining the authority in the fall, I worked for the Department of Administrative Services, which is the state agency that handles all of the back office functions for other state agencies. I have been an attorney for over 20 years, focusing on employment law, administrative law, and legislative issues. And FMLA has been a large part of my professional life. I've done training, I've helped set up the state's FMLA program and processes, and now I'm working to bring the Connecticut Paid Leave Act into fruition at the authority. We'll spend a little bit of time this morning just talking about the Connecticut Paid Leave program, and then we'll talk about how the Connecticut Paid Leave Act fits into the existing leave laws. We'll talk a little bit about what the employer is going to be doing starting next year, how employees will apply for benefits. We can talk a little bit about the private plan alternative, as well as the process to register if you haven't done so already. And I'll share some additional resources before we open it up for the Q&A. So the Connecticut Paid Leave Authority is a quasi-public agency, which was created by Public Act 19-25. That's the law that created the Connecticut Paid Leave Program and amended the Connecticut Family and Medical Leave Act. The reason that the Connecticut Paid Leave Act was passed is because the legislature recognized that there's a real gap. We have existing laws that allow certain employees to take job-protected leave, but many employees can't access those rights because they can't afford to take time away from work without payment. And those existing laws were really restrictive as to who was covered. So they passed the Connecticut Paid Leave Act to change those things. And they created the Connecticut Paid Leave Authority and gave us the responsibility for providing the paid leave benefits to employees who are out of work. So our job is to make sure that those benefits are accessible and to help employers, administrators, and healthcare providers understand what their roles and responsibilities are as they work through this process with us. At the authority, the statute requires us to engage in outreach and engagement, education opportunities like these webinars. We also have to stand up the program. It's a brand new agency, so we have to get that set up. And we've been working on the policies and procedures both to run ourselves and set forth the program. The statute sets forth the contribution maximum, which is 0.5%. In the future, once the trust fund reserves become healthy, we can reduce the contribution rate. We can't increase it, but we can reduce it. And so our responsibility is to pay attention to that and see when we can reduce it. We're also responsible for receiving the contributions from employees. As we'll talk about when I talk about the private plans, we have responsibility to review applications for plans and to audit those plans once they're in effect. And starting in January of 2022, employees will be able to apply to us for paid leave benefits. And that will start the second half of our program, which is really administering those claims. Just a few key dates. We've been doing a lot in the very short time since the law was passed. Our board of directors was first convened in October of 2019. Our CEO was hired in March of 2020, about a week before we were all sent home to work. And since then, we've just been running like mad to get this program up and established. We created our website in September, and in November, we started the employer registration. As hopefully you know, as of January 1st, 2021, employers were required to begin deducting contributions from the employee wages. Hopefully you're all doing that. We can talk about what to do if you're not. We're also reviewing applications for private plans, and we are coming very close to the first deadline for the payments to be made to us. Those contributions are remitted to the authority on a quarterly basis. We do allow employers 1 month grace period, just the same as Department of Labor and Revenue Services allow for employers for the unemployment insurance benefits and payroll taxes. So as long as you get your payments in within the month after the end of the quarter, you're on time. Our goal is to stand up the claims administration process next fall so that by December, employees who know that they will be out of work taking leave in 2022 can start submitting their applications. And then starting in January 1st of 2022, we can start actually paying income replacement benefits to people who are out on leave. The first question we always get is, who's covered by this program? And the answer is most everybody. The legislature deliberately wanted to make sure that as many employees as possible receive the protections of the Connecticut Paid Leave Act and the Connecticut FMLA. So employers who have one or more people working in Connecticut are part of the Connecticut Paid Leave program. This includes nonprofits. It also includes private sector employers with unionized workforces. It also includes employers who may not be subject to unemployment insurance obligations. But if they have employees working in Connecticut, they're part of our program. Sole proprietors who would like to participate for themselves personally, so the business owner or the self-employed individual who's not an employee, but recognizes the value in having basically an insurance program, are allowed to opt in. If they choose to opt in, they have to stay in the plan for 3 years. There are certain categories of employers who are not covered, and this is really consistent with the existing law in Connecticut FMLA about who is not covered under Connecticut FMLA, and that includes the federal government. It includes the state of Connecticut except as to our covered public employees, which I'll define in a minute. Municipalities and local or regional boards of education are also not covered unless they have covered public employees. Finally, non-public elementary or secondary schools are not covered by the Connecticut Paid Leave program. Okay, who are these covered public employees who are covered? Meaning they do remit the contributions to the authority and will be able to apply for benefits. Well, first, the non-unionized employees of the state. So managers, appointed officials, elected officials, we're all covered. We all remit the contributions. Unionized employees of the state are currently excluded, but if they collectively bargain to be included, they will become covered public employees. Similarly, employees of municipalities and local or regional boards of education are currently excluded. But if their unionized employees collectively bargain to be included, then all of the employees of that municipality or that board of education will be included, both their union and non-union staff. As I mentioned, the contribution obligation began on January 1st, 2021. The contributions are made from the employees' paychecks. The Connecticut program is solely employee funded. And they're based on employees' wages calculated the same way that employers currently calculate wages for purposes of determining an employee's FICA obligation. The contributions are also, like FICA, they're capped at the Social Security contribution limit, which is currently $142,800. So if you earn more than that amount, you only contribute up to that $142,800 number. So the employee contributes 0.5% of the wages, but the employer who's handling the payroll is the one responsible for actually remitting the contributions, together with some very minimal wage information, which the Paid Leave Authority receives. We will deposit those contributions into the Paid Leave Trust. The Paid Leave Trust is the source of the benefits and the administrative costs for the authority. It is administered by the Office of the State Treasurer, but it is not considered to be a state account. It is not state funds. It cannot be used for any purposes other than the Connecticut Paid Leave Program. As I mentioned, the Connecticut Paid Leave Act is new, but it fits into a whole environment of existing laws. So we'll just talk about those because I think it's important to understand how they fit into those laws. The first is the federal FMLA. There's also the Connecticut FMLA, which has been on the books since the 90s. Up until next year, however, you would only be familiar with the Connecticut FMLA if you are an employer with 75 or more employees, or you worked for an employer with 75 or more employees. But starting next year, it will apply to employers with 1 or more employees. In addition to the 2 FMLA acts, which provide job protected leave. Workers' compensation does include some job protection for covered on the job injuries. The Americans with Disabilities Act, the Pregnancy Disability Act, and the Connecticut Fair Employment Practices Act all say that employers must consider whether job protected leave might be a reasonable accommodation to an employee who has a disability, which is a very broad definition. So most employers have at least experienced some issues with their employees where they have to consider, should I give my employee job protected time off, or am I required to? We really don't have very many laws that require income replacement. And in fact, up until the Paid Leave Act, the primary law here was the workers' compensation, which only applies to covered on the job injuries. As I mentioned, the Connecticut FMLA is going to change on January 1st. So I really want to take a couple of minutes just to make sure people understand that it's changing. Right now, it only applies to employers with 75 or more employees. But as I mentioned, starting next year, employers with 1 or more employees will be covered by Connecticut FMLA. To be eligible for job protected leave, the reasons to be eligible will change too. Right now, the employee has to show that they've worked for at least 12 months with that employer and have worked at least 1,000 hours in the 12 months immediately preceding the date of the leave. And if so, they can have job protected leave. Starting next year, there will no longer be an hours worked requirement, and you have job protection, or you have the right to take job protected leave after 3 months of employment. The other significant change is the length of time of the leave. Right now, it's a 16-week leave in a 24-month period with the availability of up to 26 weeks of leave for military caregiver leave, which is a one-time per employee option to take time away from work to care for a family member who's been injured in the line of duty. Starting next year, the leave period changes and it's 12 weeks in a 12-month period. You'll still get the 26 weeks of leave for military caregiver. The law will also allow for an additional 2 weeks of leave for incapacitation during pregnancy. Finally, the law will change relating to employers' ability to require employees to use their earned accruals while they're out of work. Right now, an employer is allowed to permit or require an employee to use their earned accruals while they're taking leave. Starting next year, the employer can still require the employees to use accrued time off, but they can't require them to exhaust all of their accruals. You have to let your employee hold on to at least 2 weeks of accrued PTO. All right, let's just talk a little bit about the reasons for leave. These are the reasons that a person could take either federal or state FMLA or receive income replacement benefits. The first reason, sort of the happy reason, right, is to bond with a newborn child or a child that your family has recently adopted or has for whom you're providing foster care. And this is called bonding leave. You can also take leave to care for a family member who has a serious health condition, which is called caregiver leave. Of course, you can take leave if you have your own serious health condition. And that definition includes not just an injury or illness, but also serving as an organ or bone marrow donor. And it also includes pregnancy. As I mentioned, there's leave to care for a family member who's injured in the military. There's also something called qualifying exigency leave, which is available to an employee whose parent, spouse, or child is called to overseas active duty. and is for specific reasons like going to a sending off ceremony or having to take time away from work to make appointments with your lawyer and your financial advisor to set up changes due to the fact that your family member is going overseas. Separate from Connecticut FMLA, there's a separate statute that's called Connecticut Family Violence Leave. And that is a statute which says employees who are experiencing family violence can take job protected time away from work to go to court, to relocate, to receive counseling or treatment. And the statute says that you have up to 12 unpaid days in a calendar year that you can take for family violence leave. Starting next year, an employee who's taking family violence leave can come to the Connecticut Paid Leave Authority for income replacement during those 12 unpaid days. As I mentioned, these leave reasons are the same that you'll see under federal FMLA as well as Connecticut FMLA, but there is a significant difference that we want to highlight, and that is the difference in the definition of family member. Under the federal FMLA, an employee can take leave, caregiver leave, to care for their parent or their spouse or a child who is under 18 or is 18 and over and has a disability which prevents them from engaging in at least 3 activities of daily living. So it's really talking about a narrow population of people who are 18 and over. Under Connecticut FMLA, as it's amended effective January 1st, 2022, and under the Connecticut Paid Leave Act, an employee can take caregiver leave and receive income replacement benefits when they need to care for their parent or their spouse, or a son or daughter of any age, as well as for a sibling, grandparent, grandchild, or an individual related to the employee by blood or affinity, whose close association the employee shows is the equivalent of parent, spouse, child, sibling, grandparent, grandchild, right? So what does that mean? It's a new concept for Connecticut. It's not a new concept in general. The federal government has used this related by affinity standard for over 10 years in connection with federal contractor sick leave and bereavement leave. Other states and municipalities are also using it. And basically the idea is the employee has to show that they have a significant personal bond that is equivalent to one of those relationships, regardless of the fact that they're not biologically or legally related. We're really talking about sort of recognizing that not every family looks like Ozzie and Harriet Nelson, right? We all have different configurations of people who make up our family. Some of these examples might be the aunt or uncle who you take care of, you take to the grocery store and to their doctor's appointments, and who comes to every family event and is really sort of standing in the place of a parent or a grandparent. Another example is sort of your significant other. Connecticut does not recognize common law marriage. So even though you've lived together for a long time, you would not be seen as being married. But under this new related by affinity, you could show that you've maintained your familial spouse-like relationship, even though they never married. So sort of the Goldie Hawn, Kurt Russell relationship. Okay, the next 2 slides are really intended to just give you very quick, all in one place snapshot of what these 3 different laws provide. So there's a little bit of repetition, but we think it's helpful to have it all in one place. First is, how long can people get leave? Well, as I mentioned, Connecticut FMLA is changing, so we're going to talk about it as of January 1st, 2022. And both in federal FMLA and with Connecticut FMLA, you can take up to 12 weeks of leave in a 12-month period for all of those leave reasons I mentioned. You also can get the one-time 26 weeks of leave for military caregiver. In addition to those rights, which are similar between federal and state, you can get the 12 weeks in a calendar year for family violence, and you can get up to 2 additional weeks of leave for incapacity during pregnancy. The Connecticut Paid Family Leave Act says that an employee could take paid or could receive income replacement benefits for up to 12 weeks of leave in a 12-month period for all leave reasons, including military caregiver. In addition, as I mentioned, we can provide benefits during those 12 days that a person might be needing it for family violence, as well as those 2 additional weeks for incapacity due to pregnancy. The eligibility requirements, so what do I need to show in order to access these benefits, differ between federal FMLA, Connecticut FMLA, and the Connecticut Paid Leave Act. Federal FMLA says, and is not changing as far as we know, says you have to be employed for at least 12 months and you have to have worked at least 1,250 hours in the 12 months immediately preceding leave. So this really excluded part-time employees, seasonal employees, people who work multiple jobs. Connecticut FMLA, they tried to address that by saying you only have to show you're employed by the employer for at least 3 months to receive job protection. With Connecticut Paid Leave Act, we don't actually look at how long you've been employed by a particular employer. We really look at the income. If you've earned at least $2,325 in your highest earning quarter, when we look back at the first 4 of the past 5 quarters immediately preceding leave, we're going to find you eligible for benefits as long as you are currently working or you had been working within the 12 weeks immediately preceding your request for benefits. We're going to look at your earnings not just from one employer, but multiple employers. So this allows part-time workers who might have multiple jobs to access the benefits. All right, so that's sort of an overview of what the laws are and kind of what they provide. But what does this mean to employers? How do employers interact in this process? And really, what you're going to be doing in 2022 is similar to what you already are probably doing right now, which is when your employee asks for time away from work for a potentially qualifying reason, one of those reasons I listed, you must consider, is this employee eligible for job protected leave under one or more statutes? And also, is this employee eligible for any income replacement while they're out of work? You need to answer both questions each time because you may have a person who's eligible for income replacement but not job protection or vice versa. And you might have someone who was eligible last time they asked for leave, but they aren't anymore. Because the eligibility standards are different, you could have an employee who's eligible only for federal FMLA or only for Connecticut FMLA. If they're eligible for both federal and state FMLA, the leaves will run concurrently, meaning they'll be drawing down their leave entitlement from both buckets at the same time. Some employees won't be eligible for federal or state FMLA, but job protected leave might be a reasonable accommodation under the ADA, the Pregnancy Disability Act, or CFPA. And some employees won't be eligible for any job protected leave at all. The employer also needs to consider, is this employee entitled to any income? It might be based on their earned accruals. It might be because the employer has some sort of leave policy, either internally or through a short-term or long-term disability policy. The statute says that an employee can receive benefits from both the paid leave authority and the employer at the same time, but the combination cannot exceed 100% of the employee's regular wages. If you as an employer have a policy that says, I want my employees to use their sick time when they're out for their own serious health condition, you're going to be allowed to do that. And then in that situation, the employee would not come to the Connecticut Paid Leave Authority until they've exhausted their sick time. As I mentioned, you do have to allow an employee to hold up to 2 weeks of accruals. So if they've used up all their sick time, but they have vacation time, that's fine. If you have short-term or long-term disability policies, you have to look at the language of the specific policy to see what they say about the interaction between the paid leave benefits and the policy. Most policies say that they are the payer of last resort, which would mean the employee would have to use their employer-provided accruals and then come to the paid leave authority before they could access the short-term benefits. I should note that an employee who is receiving workers' compensation benefits cannot simultaneously receive benefits from the paid leave authority. That's a flat exclusion in the statute. What it's important for employers to know is that you will be making decisions about whether your employee is eligible for job protected leave, complying with the statute. You will also make decisions about what your own policies say about accruals and your benefits. Employers do not make the decision about whether an employee is eligible for income replacement from the paid leave authority. The employee has to come to us and request benefits, and we'll make that eligibility decision. The only exception to that rule is if the employer has an approved private plan, in which case the employer is standing in the shoes of the authority and administering its own private plan, in which case they'll be making the eligibility for benefits decision. So we've got an employee who knows that they need time away from work. Perhaps they need knee replacement, or they're pregnant, or their parent needs to go to physical therapy, whatever the reason is. They will be talking to you as the employer about their time away from work and applying for leave from you. They will come to the paid leave authority to apply for paid leave benefits. We are actually in the process of contracting with a third-party administrator to handle the claims administration for this. So soon we'll be able to identify who that is and exactly how the employee will do it. We anticipate sort of a multi-pronged approach where an employee can go online or call, text, whatever. But the paid leave authority will validate that the reason for leave is covered and that the employee is eligible based on the earnings. The paid leave authority will calculate the benefit amount. In order to do that, we need to communicate with the employee and the employer, both to validate that the employee is actually out of work and not receiving a paycheck, and also to offset any employer-provided paid time off to make sure the employee does not receive more than 100%. And then we'll issue the benefit payments directly to the employee. How much an employee earns depends really, in income replacement benefits, depends on how much they earn. The calculation in the statute says that if the employee earns less than or equal to the minimum wage times 40, the weekly benefit payment will be 95% of their base weekly earnings. So if you've got a $12 an hour minimum wage, we're looking at $480. So if you earn less than or $480 a week, you'll get 95%. If you earn more than $480 a week, then it's a two-part step. You get the $480 plus 60% of the difference between your weekly earnings and the $480. However, in all circumstances, no matter how much a person earns, the total weekly benefit is capped at 60 times the Connecticut minimum wage, which, if you're looking at $12 an hour, is $720. We just have a couple of examples here to just show the math for people who want to see our work, right? So if you earn $375 a week like Mike, it's just a simple 95% of 375 equals 356.25. Deborah earns more. She earns $700 a week, so we're going to do that two-part analysis, the 480 plus 60% of the difference. And so we'll see that she will actually receive $612 a week in benefits. Oops, it's not letting me move forward. Here we go. I talked a little bit about private plans. Under the Connecticut Paid Leave Act, there's no opt-out, right? People can't just say they don't want to participate. There is, on the other hand, an alternative option. Section 31-49O of the Connecticut General Statutes allows employers to apply to the authority to use a private plan to meet the obligations under the Connecticut Paid Leave Act. So these are employers who say, I know my employees have a right to have access to income replacement. I'd like to offer it them myself. In which case, the employer, not the leave authority, administers the claims for benefits. If you have an approved private plan, you are excused from the obligation to remit contributions to the paid leave authority, but the employer may continue to withhold a portion of the employee's wages, but the money can only be used to administer the private plan. It cannot be bundled in with other benefit accounts or anything like that. And if they are going to take the withholding, it cannot exceed the statutory limit, which is currently 1/2 of 1%. If you're interested in doing a private plan, there's information on our website. If you go to ctpaidleave.org and click on the apply for a private plan, or I want to apply, depending on which page you get to. The plan requirements are all summarized in the private plan policy. So the second half of the screen really is a screenshot because it provides you a great deal of information, but then you can also scroll down to checklists and to see the actual policy requirements. There are two types of policies that are private plans that an employer could offer. One is a fully insured plan, where you can contract with an insurance company who will provide you with an insurance policy. The other is a self-insured plan. Either way, the plan must offer the same or better benefits as the public plan, covering all the same reasons, for the same amount of time, for the same benefits. So a short-term disability policy is not going to cut it because they don't cover all of the same reasons as the law. As I mentioned, it cannot cost more than the public plan, and it must cover all of the employees. If you're a multi-state or multinational, it only has to cover the employees working in Connecticut. But the point is, it has to cover all of your employees. You can't have a private plan for your executive suite and then tell your sales force that they should participate in the public plan. Additionally, because the Connecticut Paid Leave Program is entirely employee funded and is intended to provide this benefit to employees, the legislature felt strongly that employees had to make the final decision about whether they wanted to use an employer-provided plan or to stay with the Connecticut Paid Leave Authority. And for that reason, they imposed a voting requirement. Your private plan must be approved by a majority of your employees working in Connecticut in order for you to even apply to us for approval. There are a number of insurance companies that have already filed the necessary paperwork with the State Department of Insurance to offer a private plan. So you can go to one of them, or as I said, you can develop a self-insured plan. We have template documents on our website. Again, in that policy tab, you'll find it. I want you to understand with a self-insured plan, the employer has to come up with the money to pay the benefits. In addition to paying for that, an employer who wants a self-insured plan must also obtain a surety bond in an amount equal to the estimated year's worth of contributions from their employees. And that bond runs to the benefit of the authority. The bond is there in case of emergency, in case the plan is unsuccessful or runs out of money. The employees who would be covered by that plan will end up at the authority. And so the contributions, the amount of money basically goes to the authority. It cannot be used as your expected source to pay for those benefits itself. We are receiving applications right now. If you get an approved application on or before March 31st of 2021, you will be excused from remitting your quarter one contributions to the Paid Leave Authority. However, you don't have a lot of time to waste. If you're interested in this, please check out the requirements. They include a 2-week notice period to your employees. So if you really are interested in this, you need to get moving now. Okay. Registration. As I mentioned, we started registration of employers in November, and about 2/3 of the employers in the state have already registered. If you are one of those companies that has not yet registered, please do so immediately. Registration enables you to be sure that you will be able to remit those legally required contributions. And if you don't have an account with us, you won't be able to. And that could result in fees and penalties for you, and it also harms your employees. If you've been having trouble getting your payroll system up and running, and you haven't been remitting or taking the deductions, there is a grace period. We've worked with the Department of Labor, which authorizes employers to take some catch-up payments. It cannot exceed more than 1% of your employees' wages, and this grace period only lasts until the second quarter of 2021, so to the end of June. So if it took you a little bit of time, you have until June to try and make catch-up payments. Okay. How do you register? Well, it's a 2-part process. The first part is to create an account with business.ct.gov. This is not something that is exclusive to the Connecticut Paid Leave Authority. Business.ct.gov, it's also referred to as Business One Stop or the Business Portal, is something that the state of Connecticut in general is rolling out for all agencies. Basically, the idea here is that businesses will create their account in Business One Stop, and then that will be their single door by which they access everything that they interact with the state on. Not every agency is there yet. It's still really new. It just rolled out in August. So you will continue to have to deal with separate agencies for a little while. But the goal is that that will be your sort of account in your portal to deal with everything you have in the state, whether it be with licensure, with DCP, taxes with DRS, unemployment with DOL. That's the goal. So we're following direction, and we're working with Business One Stop to make sure that employers get their Business One Stop credentials. If you've already done it, you're good. You can use those credentials and you come straight to the Paid Leave Authority. If you haven't, you just go to business.ct.gov, create your account, and get your credentials. Then you come back to us at ctpaidleave.org and click on the registration button, and you will register. It is, once you have your credentials, it's a really short process. It takes about 10 minutes. We just need some basic information about your business and your contact people. While you're at ctpaidleave.org, check out the other resources that we have available to you. We know that this is a brand new program, and so we want to make sure employers understand it and employees understand it. And we know that your employees are probably talking to the employers because the employers are the ones doing the payroll deductions. So we have a poster, we have a rack card, we have a paycheck mailer, a fact sheet. All of these materials are available in black and white and in color. They're all available in English and Spanish right now. And they're great resources to help explain what the program is, what the benefits are, and what's going on, including a contribution calculator and other useful information for your employees. We also have, sorry, I'm just going to go back and give everyone a moment, ctpaidleave.org. Very easy to remember. In addition to the particular information for employers and employees, there's also dedicated information for sole proprietors and self-employed individuals. Okay, before I get to the questions, I want to just give you what to remember. If you haven't done so already, register. ctpaidleave.org. It'll save you a lot of headaches in the future if you register now. If you have a third-party payroll advisor or provider, they're most likely already well underway. They've probably been doing your deductions already. We've been working with them since April, but it's always just a good idea to make sure you are on the same page with your provider. Educate your employees using the information I shared with you, and make sure that they understand what's going on and that they know where they can go to ctpaidleave.org for information for themselves. And, bookmark us. We have updates on our FAQs, on our videos. We have a video on how to register. We have videos about the program. So come and check us out. If you can't find the answers to your questions in the FAQs or the videos, we have a contact us portal. You can submit your question and we'll respond to you either by email or by setting up a conference call. So we're trying to be as responsive as we can and answer as many questions as we can. And with that, I'm going to stop sharing so I can answer your questions right now. Amber, have any come in?
Thank you so much, Erin. I appreciate it. So we do have a few questions, not too many. This first one is, how does the program partner with an employer's internal paid short-term disability program?
Right. So I'm not entirely sure what you mean by an internal short-term disability program. If
Well,
it is
there's a little more context that I can give you.
Sure.
It says, for example, if we as an employer pay an employee 70% of their salary during the first 90 days of disability, how does this work with the Connecticut paid leave?
Right. So in that situation, if you were to continue to pay your employee 70% of their salary, that employee could come to the Paid Leave Authority to make up the difference. And so they could get income replacement different payments to make up the difference. Alternatively, if you have um, a program where you say you need to use your accruals, but it's not going to cover 90 days, or perhaps you have a program where you only cover your employee's own serious health condition, but you don't provide any paid leave benefits for bonding or for caregiver or for military, then you will continue to provide your generous policy for your own serious health condition, and your employees will come to the paid leave authority when they need income replacement, when they take leave for those other issues.
Okay, great. Thank you. Are employees required to apply for the state paid leave if they prefer to just use the employer's internal paid leave?
So that is going to depend on the employer's policy. So employers have the right to require or permit the employee to use their accruals. So no one is going to require an employee. Well, let me put it this way. The paid leave authority is not going to require employees to apply to us, but your employer may. So it's going to depend on what the employer decides.
Another person says, we use a third party to submit contributions. As the employer, do I also need to register?
So great question. We do have a relationship with a third party, all of the large third party payroll processors, and they are busy uploading on a batch basis all of their clients based on the information they have. But so you're kind of minimally covered if your third party provider has done that or is planning to do that. However, they don't necessarily have the information that you have in terms of who at your business you want the leave authority to contact in case of questions or in the future when employees come out for benefits. So if your third party provider has batch registered you, that's great, but you probably still want to go in, make sure you know where your account is, and get yourself credentialed, because in the future we're going to need to contact you and you're going to want to tell us who to contact.
Thank you. Next question. Will I be able to quarterly file and pay through QuickBooks payroll like I do with the Connecticut Holding and Unemployment? As of 2 weeks ago, QuickBooks did not have any information from you about that process.
Right. So QuickBooks did update its software to make sure that you're able to do the withholdings. We are currently still in the testing process for making sure that the benefit payments come to the right place. We're doing a very rigorous testing process because we want to make sure that when the money is actually remitted, that it goes to the correct bank account. So there is information that we're developing and testing. In general, I can tell you that we do have a couple of different ways that employers can remit their payments. One is through sort of a batch process. The other is to go to ctpaidleave.org and basically click on the pay here button through your account. And we are developing checklists and information guides for employers for how to do that.
Great, thanks, Erin. Can an employee receive paid benefits for intermittent leave?
Yes, the statute specifically says that an employee can receive income replacement for absences of less than a full day. So and we understand that for a lot of people, if you're out of work on an intermittent basis, which means so if you're partially at work and partially out of work, you still need that income. So we will be able to provide income replacement on an intermittent basis.
Okay. And will there be any issue between the Connecticut paid leave and getting benefits from commercial short-term disability insurance?
Right. So as I mentioned, there's not an issue, not in the sense of a problem, but there is a need to do an individualized assessment of what your own commercial short-term disability insurance provides. If it is an employer provided benefit, then they could be received simultaneously, but it can't exceed 100%. And you just need to look at the terms of that actual policy to see if they say use us first or if they can be done concurrently.
Great. If anyone else has any questions, please go ahead and drop them in the QA at the bottom of your screen. In the meantime, I'm going to give everyone the link to our Connecticut Paid Leave website.
Yeah, I'm looking at the chat. It does look like a few people put some questions in the chat, so
There they
instead
are.
of making them retype it, I'll just answer. So
Okay.
the 12-month period, what is it? Measured forward, is it back, calendar year? So for both federal and state FMLA, the employer is entitled to establish its 12-month period. So, and both laws sort of set out your 4 options, and you get to decide which one you want to use, and you just have to notify your employees. The authority will have its own 12-month period because, again, the eligibility are different. People may not come to us as soon as they go out on leave. And we'll be doing a rolling. We're finalizing whether it's a look back or a look forward, but I can guarantee it's a rolling. It won't be a calendar year because in my experience doing FMLA, a calendar year really creates stacking, and it's really the worst option in my opinion. Another question is how much to be eligible, how much time does an employee need to have worked in the past 12 weeks? 1 day, 1 hour? And does work include wages received for paid time off like vacation? Great question. So I think this is in connection with the issue about in order to be eligible for income replacement benefits, you have to either be currently employed or you have to show that you were working before you were out. We are finalizing the policy on what exactly we'll be requiring, but I can tell you the intent behind that provision was to make sure that employees who are not eligible for job protection and therefore lose their job because they're experiencing a serious health condition or they have to take time away from work to care for their parent, who are sort of in the most need for income replacement, are still able to access it. So we are finalizing the details about what you have to prove to us, but it's meant to really provide that protection. I can tell you also that you can't really work 1 day and still knit the 23-25. So that's how we're finalizing that. And then when the time comes for making the actual payments from the employer to the paid leave, what are the steps? We are doing our own payroll. Right, I kind of mentioned that in the Q&A, in response to the Q&A question, where we do have, there are 2 ways of doing it. One is through a batch. One is just sort of going to the website itself, and there'll be a process there. We are developing videos and FAQs and guides to employers. So those will be up and available soon. I personally have not been very much involved in that technical side, so I can't answer those questions, but please check ctpaidleave.org and we will get that information out. I anticipate we'll also be doing webinars on that as well. Not by me. Thank you, Donna, for putting it in both places. So keep a lookout for that. I know we have information on the coding that you need to put in. And so we will be continuing to provide more and more information on that process.
Excuse me.
All right, we are at 12:50. So if anyone has any other questions, I'm happy to answer them. If not, I would like to remind you again to go to ctpaidleave.org, check out all the information we have there. Make us a favorite. What information will employer need to provide before a claim is processed? And is it mandatory that it be submitted before a claim is approved? Well, let me start with what the employee needs to provide. The employee will need to provide information so that we can validate that they're eligible based on their income and that the reason for leave is covered, which will include some documentation. If it's a serious health condition, we'll need a medical documentation. If it's caregiver leave, we'll need documentation from the person who's ill. If it's military leave, we'll get military orders. We will determine if we need, what information we need from the employer, depending on the circumstances. We do have access to information from Department of Labor and Revenue Services, so we'll hopefully minimize the information we need from the employer. But at a minimum, we know we'll need to make sure that the absences are validated, and we'll need information about offsets. Another question is, what is considered working in the state since most people are working remote now? Great question. We are using the same standards that Department of Labor uses for determining what state an employee works in for unemployment insurance purposes. We know that a lot of employees are temporarily, extended temporary, but temporarily working from home, but they expect to go back to the office. And so, if that's the case, Department of Labor has said, we'll treat you as though you're still working in the office and you're working there. Other situations, or if your work from home is going to be permanent, there's basically a 4-step analysis that goes to where you get your direction and control. But the short answer is, if you pay unemployment, we're going to follow whatever state you pay unemployment to. So it looks like we had a couple of last questions. How long is the period between the application and approval of benefits, and how soon would the employer be notified so that you don't pay too much? Great question. We are, as I said, we are actually in the process right now of contracting for a third-party administrator. And once they're on board, we will be able to really develop the policies and procedures. So I don't have specific answers right now. We are, generally speaking, looking at the same timeframes that already exist under federal FMLA, which requires, under federal FMLA, when an employee comes to you for a job protected leave, you need to tell them within 5 business days if they're eligible, and notify them if they need to provide you with any additional documentation. And then the employee has 15 calendar days to provide that. And then you have time to tell them if they're eligible for benefits. So that's generally the expectation, but we don't have all those details finalized. Please know that our efforts are to make sure that we provide both employees and employers with timely and efficient services so that we don't have a lot of overlap or extra bureaucracy. So Amber, there are 2 questions about the slides and the video. Could you answer those? When will the slides be available and the video be available?
Sure. So everyone who's registered for this webinar will receive a follow-up email from Zoom in 2 days. And that follow-up email will include 2 links. One link will take you to a PDF version that you can download of this presentation. The other link will take you to our YouTube page for this recorded webinar. And that'll be in 2 days.
Thank you, Amber. All right. Well, if there doesn't look like we're getting any other questions coming in, so we can give everybody 5 minutes back to their afternoon. Thank you so much for participating in today's webinar. We really hope that you get some good information from this. If you have additional questions, please go to ctpaidleave.org and click on that Contact Us. We have a team who is responsive to that. It's the best way to get the fastest information. If they need to escalate it to me, they will. There's a great team who's handling a lot of those questions. You can also check out the FAQs and the videos on the website. All right. Well, thank you so much. I hope that everyone enjoys this sunny afternoon. Hopefully we'll get more sunshine and nicer weather as we get into spring.
Thank you so much, Erin. Thanks everyone for joining us. Have a great day.
Bye-bye.